when I got ready to do this speech, I asked Joe what he wanted me to talk about today, and he had a bit of a long list for me. So he wanted me to tell you how I got into the pro-life movement, talk about Casey and other decisions that led up to Dobbs, discuss the law review article and our brief in terms of the viability issue, and also talk about the Dobbs decision and the implications after that. That's a lot, so I'm going to try to get through it, but I may be moving a little fast. How I got into the movement, kind of an accident. I got out of law school and I didn't know what I wanted to do, but I wanted to do something good and with a purpose. Into a professor of mine and told him that, and he said to me, well, I think you should volunteer. I don't have any money to pay you. You'll get good legal experience, and it'll be doing something worthwhile. I'm going to try and jump to Joe's second point now, cases leading up to Dobbs. I left AUL after several years and headed to a new job in Pennsylvania. Not long after this, however, the Supreme Court granted review in Webster. That was a Missouri case, and the legislative matters that we were considering were put on hold because we wanted to see how the court would rule. In the interim, Justice Scalia and Justice Kennedy had been appointed to the Supreme Court, so there was some hope that the court would overturn Webster. Justices Rehnquist, White, and had dissented in Roe itself, and Justice O'Connor had been a persistent and severe critic of Roe, saying that its trimester framework was unworkable itself and had already caused significant distortions in the law. And Justice O'Connor had also proposed that Roe's strict scrutiny standard for reviewing abortion legislation be replaced with an undue burden standard, which appeared to allow regulation much more broadly, as long as it did not include act to be an absolute obstacle or severe limitation on the abortion decision. If both Justices Scalia and Kennedy joined Rehnquist, White, and O'Connor, there would be 5 votes to overrule, at least in some. Was decided in 1989. There were only 4 justices who voted to overturn, including Justice Kennedy, rejected the trimester framework of Roe v. Wade, and Justice Scalia voted to overturn it in its entirety, saying that there was no constitutional right to abortion at all. Justice O'Connor, however, did not join that opinion from Justice Rehnquist. Instead, she said that if you properly construed the language of the statute, it didn't actually conflict with Roe, and that there was no need, if you applied her undue burden standard, not the strict scrutiny, if you applied her undue burden standard, it was constitutional. In the issue of constitutionality of Roe wasn't necessary. And then she ended by basically encouraging people to pass unconstitutional laws, because she said when the constitutional invalidity of a statute actually turns on whether Roe itself is constitutional, that'll be the time we look at this. So Justice Scalia pointed out to her that she had pretty much foreclosed, in his view, the chance of ever overturning Roe, because it was unlikely that anyone would pass a statute knowingly being in conflict with Roe. He said that can't even be argued with a straight face. Maybe Justice O'Connor was counting on that and deemed it unlikely. I don't know. But anyhow, prior to this point in time, legislatures had consistently been trying to pass regulations that Roe, maybe pushing a little bit here and there, but no one was really trying to conflict with Roe. We were trying to have the laws upheld. So it was rather strange time. kind of having to reverse your whole intent and your whole approach to drafting legislation. And now we were faced with the possibility of trying to convince a legislature that it should pass a law that contained provisions that were clearly in direct conflict with Roe, and then trying to get our governor, who had just vetoed, remember, a statute because it was in conflict with Roe, we were trying to get him to sign that law. Anyway, we did end up passing a law and getting the governor to sign it, which contained two provisions that were in direct conflict with Roe. That was promptly challenged by Planned Parenthood and other providers, but they apparently didn't want to test the question of Roe versus Wade, so they did not challenge the two provisions that directly conflicted with it and simply addressed all the other ones that were like informed consent, parental consent, reporting requirements, and that. So we had to go forward without the two provisions that clearly conflicted with Roe and other cases. I assisted the Attorney General's office in defending the statute from the trial court through the Supreme Court, and we proceeded under the premise that the current standard that commanded the court's majority was O'Connor's undue burden standard, because if you counted the 4 votes for overturning, hers was the most narrow grounds upon which you would proceed. And so the AG's office was okay to go forward with that. And we had, at trial, there was a whole host of terrible facts that the trial court found. They were made up, the worst case scenarios, a facial challenge. You don't really have to show that any of this is going to happen. You just claim that someone might do this and that and the other thing. So the judge made very, very bad factual findings and ultimately ruled against us. Ironically, it turned out to be one of the best things that could ever happen, because when the Supreme Court ultimately upheld those provisions based entirely with those worst case scenarios in them, everyone in the whole country could go forward and use that language, because nobody could come up with worst case scenarios that had already been upheld. So, you never know. God works in strange ways. I was irate when it first came down, but it turned out to be good. At any rate, he ruled against us. The Third Circuit Court of Appeals, though, bought after 12 pages of decision, trying to figure out what the proper standard was, bought our view on that. And so they went through the statute and they upheld all of the provisions except for one, the spousal notice provision, under Justice O'Connor's undue burden standard. While the case was proceeding, Justice Brennan retired in 1990 and Justice Souter was appointed to the court. And 2 days after the Court of Appeals ruled in the Casey litigation, Clarence Thomas was sworn in as a new judge. So when Casey finally reached the Supreme Court, there was a fair amount of excitement. And the pro-life movement felt pretty confident at that point, and there was a great deal of fear on the pro-abortion side. Neither Justice Souter nor Thomas had an opportunity to rule on an abortion case at that point. We believed strongly that Justice Thomas would be a strict constructionist and that he would not support judicial activism of Roe. We were less certain about Justice Souter because very much about him, but he was still a possible vote for an overturn. So it looked like we had probably 5 or 6 votes and possibly 7 to overturn Roe. Well, Casey was in 1992, and to the shock of many, myself included, only 4 justices voted to overturn Roe. That was Rehnquist, White, Scalia, and Thomas. Only 2 justices would have reaffirmed Roe as originally decided, and that was Blackmun, who wrote Roe, and Justice Stevens. The other 3 justices, O'Connor, Kennedy, and Souter, issued a joint opinion purporting to reaffirm Roe on the basis of stare decisis, which is a judicial principle that states that you should not disturb settled precedents. But then, and it did then uphold all of the provisions except for the spousal notice one, a couple of things that struck me from the decision. First, I found that the joint opinion appeared to be quite weak. Very glaring inconsistencies in it. Not the least of which was that they claimed to be reaffirming Roe, and at the same time, they clearly were striking whole sections of Roe. So, and they were doing this supposedly on this principle of stare decisis, where you don't overturn anything. So they jettisoned the trimester framework, which, of course, Justice O'Connor previously had said was an overturn of Roe, and she couldn't do that in Webster. So now here she is saying we're not overturning Roe, but she's doing the exact same thing that she said wasn't overturned before. So at any rate, they overturned the trimester framework. They expressly overturned two prior decisions, Akron and Thornburg, that relied on that trimester framework. They changed the constitutional underpinnings of Roe from a right of privacy to a right of a liberty right under the 14th Amendment. Privacy was kind of in the penumbras somewhere. And they also rejected Roe's strict scrutiny standard of review and replaced it with the undue burden standard, not the same one in Akron, a little bit more confusing one, as will be obvious from the subsequent cases trying to apply it. But I have often wondered whether the justices who signed on to that opinion were subsequently somewhat embarrassed by its weaknesses and inconsistencies. I have no way of knowing. But it was, in my view, rather, it was not a well-reasoned opinion. It was really much more emotionally charged, and an opinion that was, they had a result they wanted to reach, and so they were trying to backfill in reasons for it. I noticed that Justice Rehnquist had written a draft opinion, which he circulated, and it was date-stamped the 17th of June. That opinion said, opinion of the court, which suggests very strongly that that was based on 5 votes at least, that he was writing for an overturn. And so that was June 17th. On June 26th, he issues a new opinion that says it's a concurring and dissenting opinion. So somewhere in those 9 days, he found out that he didn't have 5 votes anymore. So interesting, but when you look at that, as the 17th he thought he had 5, the people who went off of that decision didn't have a whole lot of time to write a decision. And so when the opinion dropped 3 days later, I don't know why, but it was not a very well-reasoned opinion. But if you look at Dobbs, you realize they don't really have a lot to work with, so maybe that was just a flaw in the whole process of it. And it didn't have anything really to do with the short period of time. The second thought I had that I wanted to share was another fortuitous point in this whole Casey saga. The court focused almost singularly on viability, and it kept saying repeatedly, viability is the core of Roe versus Wade. It's the most essential part of Roe versus Wade, and that's why they were claiming that you could do away with the trimester framework, which, of course, and Roe versus Wade didn't think it was non-essential. He drafted the whole statute type of limits in his, and then reiterated it in the summary. So, I mean, if it was not essential, I think it was news to him. But anyway, when you look at their singular focus on viability as a central holding, I think it was, in many respects, the downfall of Roe, because Roe I mean, the viability concept itself is so indefensible in terms of its logic, its analysis, it's picking it out of thin air. And so I think that whole focus on it then put all of our focus on it, which then when we started researching and you go like, wait a minute, what is this viability thing? It's not really a real concept. It has no meaning in terms of the context of abortion. It's a concept. When I did all the medical research on that, you can't find viability in a medical journal talking about it in the context of abortion. It's always in a non-abortion context. At least I couldn't find anything. And it's always in a non-abortion context where there's an anticipated premature birth, which is out of the control of the doctor and the mother. And they're trying to figure out a medical reason why, what they should do. Is the baby viable or not viable? If it's viable, then we can proceed in this manner. If it's not viable, well, it's going to be futile or whatever. We don't do we don't give the drugs. We don't try and have the baby born in a NICU. And so it has much understandable rationale for it in the non-abortion context, but almost none in the abortion context, because many of the features that go into the question of viability are whether you do provide prenatal care in the terms of corticosteroids to mature the lungs prematurely, or whether you do give magnesium sulfate or try to delay the delivery, and do you put them in a NICU so there's quick resuscitation and intensive care. Without those things, you're not going to have viability varies hugely if you have all those care factors that are external versus you don't give any of that. Babies can't breathe on their own, obviously, at a certain stage. You have to help them with ventilators. So all of that on one side is important, but when you look at it in the context of abortion, none of it's important. You're trying to enhance the survivability of a baby in the non-abortion context. In the abortion context, you're trying to kill the baby. So you're not going to get drugs. You're not going to give birth in a NICU. You're not going to do any of those things that go into a normal assessment of viability. So you're comparing apples and oranges. Basically, it's not a valid comparison. But anyhow, sorry I got long on that. But what is interesting about the choice of viability is in Casey, they really dismissed a lot of this with a one-liner. Oh, it's a reasoned statement. The court gave a reasoned statement elaborated with great care as to why it chose viability. Really? Well, there are 3 sentences in a really long opinion that talk about viability. None of them in any way, they're just bald assertions. None of them in any way actually explain the relevance of viability in the context of abortion. So and to say nothing of the fact that when you look at Blackman's papers, it's completely arbitrary. He's got a first draft that was on vagueness, a second draft that was set on his opinion in Roe that set the cutoff at the first trimester, the end of the first trimester, not at viability. So his earlier draft came out with first trimester, and then he puts an accompanying memo with that says, I realize that this and viability are equally arbitrary, his own words. And then he says, well, but, I'm thinking our first trimester now. Well, then there's ongoing back and forth between the justices, and somehow they come up with, we're going to choose viability. And, to me, it's like, well, okay, I know there's some horse trading, but really. He says on one of his memos, well, I could support viability as long as it would control a majority. and this is why we're making this decision is based on majority votes. At any rate, it was pretty clear from reading his papers that there was no valid reason. It was just a whatever, because viability isn't mentioned in the Constitution, for sure. Viability wasn't mentioned in any of the statutes that they were reviewing. None of the parties mentioned viability as a point that they thought should be reviewed or ruled upon. It just was a creation of his own and some of the other justices' determination. And it clearly was not a judicial function that they were engaged in. They were really much more doing legislative trading or compromises, if you will. And Casey itself, interestingly, says that courts may not draw arbitrary lines, right in Casey. Only legislatures can. Odd. But anyhow, and there's so many problems with viability. You know, the whole idea of linking the value of the baby's life, because that's what it really marks, is the value of the baby's life. You're linking that to a shifting point in time that goes with technology. The better the technology is, the more expansive the baby's rights get, and the more narrow the woman's rights get. You got to remember, it's kind of like a teeter-totter. Casey tries to pretend as if they're separate. There's the woman's right over here, and the baby's right over here, and you can be wrong on one and right on the other. And it's like, well, no, that whatever limits the woman's right is the baby's interest. So as the baby's interest expands, then the woman's interest contracts. So kind of for any number of reasons, viability was a really bad choice to pin the central holding of Roe on. But I'm glad that they did that, because it made it much easier to attack. So I'm not going to get in. I'm moving into Dobbs. And am I too long? Okay. Sorry. I'll go very quickly through Dobbs. I was only going to give you the basics anyway. 15-week cutoff with a maternal health and physical life and physical health exception, very similar to the one that we drafted in Pennsylvania. And the majority opinion written by Alito, Thomas, Gorsuch, Kavanaugh, on behalf of Thomas, Gorsuch, Kavanaugh, and Barrett. Then Justice Roberts wrote a concurring opinion where he said he would uphold the 15-week cutoff but not overrule. And the Breyer wrote a dissent for Sotomayor and Kagan as well. As you know, they overruled Roe versus Wade and Casey, and they returned the authority to regulate abortion throughout pregnancy to the people. And they established that a standard of review would be rational basis. So it was a very strong overturn with a lot of ability for the states left. I'm not going to get into, because I'm cutting here, the specifics of what they based it on. It was a well-reasoned opinion. They basically said that stare decisis factors didn't make any difference in terms of their overturn, because it wasn't really settled law, and which is one of the requirements, and Roe had already been overturned in Casey and other cases. And the undue burden test is clearly unworkable. Let me see. One of the things, just looking at the cutoff of viability, one of the things they said is that it's reasonable and fair. Well, those are very subjective determinations. They're not, on whose grounds is it reasonable and fair, and on what basis? And why is that more fair than a 15-week cutoff? And who decides? So those were interesting pieces of it. The dissent really didn't have any response to those issues that were raised. So I just want to mention, 3 or 4 points. I don't want to get yanked off with the cane next or whatever it is. At any rate, a couple of points in the dissent that just struck me as very shocking and appalling. One is they keep falsely, repeatedly in the dissent, referring to the fact that Roe and Casey affirmed that a woman has a right to abortion in the, quote, first stages of pregnancy or, quote, early on in pregnancy. Now, those decisions said that you could have an abortion clearly up until 24 to 28 weeks. That's 6 or 7 months. Who in their right mind thinks that that is early in pregnancy? I mean, it's not. But it's a deception that they keep trying to lull people into, and it's very, very dishonest, in my view, to keep saying that this is early in pregnancy. Well, yeah, early in pregnancy, middle pregnancy, and late pregnancy, too. They allowed it all. So, it's a really bad piece of misinformation to keep repeating. And one of the things that I wondered whether, they say it's a reasonable and fair decision to market at viability. Well, why do they keep trying to hide then that it's in early pregnancy? I think they're not really comfortable with what they've done, but they're just going to stick with it. Okay, I'm done. I'll take any questions unless Joe doesn't want me to. I guess he's going to let me take some questions.
Yes, question here.
The question, I think if I heard it right, could I comment on Justice Roberts and what he did? I can, carefully. Basically, he said that he didn't wish to overturn Roe, that he would uphold the 15-week ban of Mississippi, and that viability had to go. Now, I wonder how you do Roe if you agree that viability has to go. So he would do away with the viability standard. I guess all he means is that is left is there is some right of the woman, but he's not willing to say what it is. It's not strong enough to overcome a 15-week ban. Where he would draw the line, I have no idea.
We want to thank you so much for all that you have done and encourage you to keep pushing forward. And we know the battle's not over. We'll be praying with you. And what way can we do that more? What support do you need?
I always need support on prayers. I never would turn down a prayer.
So there's been a lot of talk in the media about Congress codifying Roe v. Wade. I don't know that they have the authority to do that. I assume they try to use the Commerce Clause to do that. If they did that somehow in the future, what do you think that would look like as it pans out in the courts under Dobbs?
If they can do it, and there's a question on that because I've gone round and round with a colleague or two of mine on it, and I'm not sure where everyone stands, or I haven't looked at that. I haven't researched it in great detail or anything. It's just off the top of my head. But if they could do that, your question, I think, is if they passed a statute, a federal statute, that not banned, but permitted abortion throughout pregnancy or without any ability to regulate it at all, under Dobbs, they're giving it back to the people. So it, I think, would have to be said to be okay if it's under other principles permissible to do that. Why we have to make sure that doesn't happen.
Okay, one more question.
Thank you, Maura. I had a question regarding Judge Kavanaugh's concurring opinion on the Constitution requiring judicial and constitutional neutrality with respect to abortion. Do you buy that argument? Because other amici submitted briefs in that opinion related to Dr. Hellerstadt's contention that under the 14th Amendment there are potential personhood rights and interest here, but Judge Kavanaugh seems to dismiss of that and say, just get the judiciary out of here.
Well, and that's why the earlier question that I don't think there's really the votes on the court to have a personhood or anything, in that way, because I think the court has been struggling with this issue for 50 years. They shouldn't have stepped in it to begin with, and they would like to extricate themselves. So, and it is very consistent with their judicial philosophy to not take sides in a way, because there's nothing in the Constitution, in their view, on the abortion issue. If you look at both Casey and Roe, they both acknowledged that this is not like the contraception. It is like the contraception cases, but it's not, because it involves the purposeful taking of a human life. So that in itself makes those decisions kind of to the side. But I think you could certainly make the argument, which is, excuse me, my body, my choice. You have that choice to use contraception or not, to prevent yourself from getting pregnant or not. But once you have done something that gets another individual, a baby involved, then the whole calculus changes. And so, I don't know if I answered your question either.
Well, with that, let's return our thanks to our speakers.